Hello, Rudy sir. Sir. Hello, sir is not, sir, no, sir voice is not hearing, sir. Please unmute, sir.
My voice is not fine, ma'am.
Yes, sir, audible? Your voice is clear, but our principal's video is unmuted, sir.
Hello, sir. Sir, now you have to stop your screen sharing, sir.
Okay.
Rudy sir, principal sir, mute. आगे तम ठहरता रोडी sir.
Hello, sir. Unmute access button nodri.
Yes. Okay.
You mute ಮಾಡ್ಕೋಬೇಡ್ರಿ sir.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. Just start ಮಾಡ sir. Sir session start ali. Okay.
Sir start ಮಾಡಂದ್ರಿ?
Yes.
Okay.
Still some 2-3 minutes no?
Yes, sir.
Hello, sir. Unmute access button nodri.
Okay.
Sir, exactly I will start at 11 o'clock, sir. Rudy sir.
Yes, sir.
Okay.
ಇಲ್ಲ ಸರ್ ಇದು ನಿಮ್ದು ಸರ್ ಇದು ನಿಮ್ದೆಲ್ಲಿದೆ ಅದನ್ನ
Hari sir. Okay. Rudy sir, can we start event, sir? Hello?
Second number, madam.
Okay.
Yes, madam. 1 second, you have to start.
Okay, sir. Thank you.
Start.
Okay. Good morning. Namaste. A warm welcome to all participants from Karnataka and from other states. I am Srimati Sridevi Mane from the Department of Chemistry. VV Sanghas, Sri Kaskatesha College of Arts, Commerce and Science, Talikoti, under the initiative of IQAC, one-day national level workshop on fundamentals of intellectual property rights organized by the Department of Zoology, Chemistry and Physics in collaboration with National Intellectual Property Awareness Mission, NIPAM. IPR is the legal right given to the inventor to protect his invention for a certain period of time. Nowadays, it is essential too. From this event, surely we all get more information from our resource person. In this regard, now I would like to request Dr. A.S. Alarmach, IQAC coordinator of our college, to give welcome address for opening ceremony. Over to Dr. Alarmach, sir.
Am I audible?
Yes, sir.
Thank you, ma'am. A very good morning to one and all. Respected resource person of today's one-day workshop, national level workshop, Sri Abhishek Singh Ji, Chairman of the VV Sangha and College Governing Body, Honorable Sri VC Remat sir, President of this workshop, and our beloved Principal, Professor R.V. Jalwadi sir, and my dear colleagues, all the participants, a very good morning to one and all. It's my proud privilege to welcome today's resource person, Sri Abhishek Singh Ji, Assistant Controller of Patents and Designs, National Intellectual Property Awareness Mission, NIPAM, Patent Office, New Delhi, on behalf of our institution, staff members, and on behalf of all the participants, I heartily welcome to you, sir.
Thank you, sir.
I also would like to welcome the Chief Patron, Sri VC Remat, Honorable Chairman, Veerashaiva Vidyavardhaka Sangha, and Chairman, College Governing Body, SK College of Arts, Commerce and Science, Talikoti. Respected Chairman, sir, on behalf of our college and staff members, a warm welcome to you, sir. I also would like to take this opportunity to welcome the patron, Professor R.V. Jalwadi, sir, Principal, SK College of Arts, Commerce and Science, Talikoti, to this one-day national level workshop. Dear sir, heartily welcome to you, sir. It is my bounden duty to welcome the heads of the departments, Organizing Secretary, Sri K.B. Desai, Convener of this workshop, Srimati S.S. Mane, Ms. N.R. Chokimat, Co-Convener, and the event coordinators, Sri I.V. Rodgi, Sri G.B. Kulkarni, and Ms. S.M. Biradar. The distinguished faculty members, participants from various colleges in and across the states, the principals, IQAC coordinators, learned scholars, both print and electronic media friends, invitees, and my dear colleagues, ladies and gentlemen, a warm welcome to you all to this one-day national level workshop on intellectual property rights. I hope this event will be fruitful with the interaction of the resource person. With these few words, I conclude my welcome speech. Thank you one and all. Over to ma'am, Mane ma'am.
Thank you, sir. Now I would like to request Ms. Sudha Biradar to introduce our today's resource person, Mr. Abhishek Singh, Assistant Controller of Patent Design, National Intellectual Property Awareness Mission, Patent Office, New Delhi. Over to Sudha ma'am.
A very good morning to everyone. It is my pleasure to introduce our resource person, Mr. Abhishek Singh, who has graciously accepted our invitation to join us today. Mr. Abhishek Singh has completed MSc in Physics from Jawaharlal Nehru University and MTech in Applied Geophysics at IIT Roorkee, and he was worked as a teaching assistant in the University of Pittsburgh, USA. He has also cleared JAM joint admission test to IITs in geophysics and secured All India rank 6, and also physics secured All India rank 52. Besides being, he also qualified GATE in physics and secured All India rank 270. And also he is NET qualified. He has worked as an examiner of patents and designs from 2016 to 2023. Currently, he is working as assistant controller of patents and designs at Patent Office, New Delhi, Ministry of Commerce and Industry, Government of India. With these few words, I conclude the introduction of today's resource person, Mr. Abhishek Singh. Thank you.
Thank you, Sudha ma'am. So here is a thank you, Sudha ma'am. So here is a small instruction to all the participants. After the resource person's speech, there will be a discussion. You may drop your questions into chat box or you may directly interact with the resource person. And all the participants are requested to mute your audio and video before the session starts. Now, it is my honor to invite our resource person, Mr. Abhishek Singh, to deliver his speech on fundamentals of intellectual property rights. Over to Abhishek, sir.
Thank you, ma'am. Thank you so much. First of all, please let me share my screen. Is it, ma'am, can you please see it? Can you see the screen? Can you see
Yes.
my presentation?
I can see, sir.
No, it is in full screen mode. Is that okay
No,
now?
sir. It is of a small reason it is there.
Just a minute, ma'am.
Hello, sir. You have to show full screen, sir.
Yes, sir. Is it better now?
Now, sir, we can't see the
Okay,
PPT, sir. Sir, your slide is not visible. Yes, now it is available.
Now is it in full screen, ma'am?
Yes, sir. Now we can see
Okay.
throughout the screen. Okay.
Okay, ma'am. Thank you very much. First of all, I would like to convey my sincere thanks to all the participants who are here, especially the students who are showing their interest in intellectual properties. Because maybe like 7-8 years back, it was not very much famous in India. The legal framework was already there. Everything was running good, but now the government is trying hard to make it aware to every part of the country, especially among the students. We are trying to reach out to the students, to the faculty members, especially in the world of academia and also in the world of corporate worlds and industry. We are trying to make people aware about intellectual property as much as possible. So I would like to convey my sincere thanks to all the students who are showing their interest in intellectual properties, and my sincere thanks to the organizing committee. My sincere thanks to the principal sir, the chairman, the participants. A special thanks to Girija ma'am, who reached out to us and she requested multiple times. Like she was in continuous touch with us, and we were working on dates, and eventually we got to the conclusion that on this date we will be organizing the program. And so a special thanks to ma'am, the principal sir, chairman, organization committee to give us the opportunity to make the students aware about intellectual properties. Now, we definitely understand that for many of the students, this is the first time they are getting in touch with the knowledge of intellectual properties. So I would try to make the session not too much complicated or not too much technical. So I want to assure the participants and the students that I would keep the session a bit light so that you could understand and grasp the basic knowledge of intellectual properties smoothly. So before I go ahead and start the session, I would request you all to note down that there is one website on the screen. I have written one website in the bottom of the first slide, and the website is ipindia.gov.in. This website is very important. If you are in your BSc first year, second year, third year, maybe you will go for masters, maybe you can go for research. So if not today, then tomorrow, especially since you are from the world of academic background you have. So if not today, then tomorrow you will definitely need this particular website when you are planning to, suppose, write a book, or if you are planning to do some, if you invent something, if you write a book, you write a poem, you write some literature, you paint something, you sketch something, you are planning to go for a startup. In all those situations, you would like to have some knowledge on intellectual properties, and that knowledge is available on this website, ipindia.gov.in. This particular website is, you can safely say that it is a kind of mother website for all the information about the intellectual properties in India. Okay, and if you visit this website, then you can see that the information about intellectual properties, it is very clearly in a classified way. It is available over there. It is a government website. So all the information is authentic, and it is classified in patents, design, trademark, copyright, everything is available there. All the acts, rules, manual, everything is available there, and the information is authentic. So I want to convey that this is a government website. When I am speaking right now, I am sitting in Patent Office, Chennai, and I am here like I am a government servant. My job is to examine your work, to decide whether the patent should be given to your work or not. So the information that I want to convey very specifically that whatever the intellectual property information or intellectual property rights that is given to you, that is given by the government itself. We are working on the behalf of the government. No private agency is involved in deciding the intellectual property rights to you. It is the government only which is, and it is central government, no state government. Okay. So before I go ahead and go deep into the session, one disclaimer I particularly want to give, that in the due course of the session, I will be taking the names of maybe some companies, maybe Coca-Cola or some companies I will be taking the names. But I have taken those names as examples so that you could understand things easily, not because of any kind of advertisement we are seeking here. No, we are not doing any kind of advertisement in any form for any company or to anyone. Okay. Now, I will start from the very basics of the intellectual property, and going to the level of the audience, going to the level of the students who are in their BSc first year, second year, or third year. I am going to start with the very basic of intellectual property, and then I will go in a bit of advanced slide. My session is on intellectual properties, the fundamental of intellectual properties. Then the question is, what is intellectual properties? Why I am here, and what is the meaning of protection of intellectual properties? What is the meaning of intellectual property? I am starting it with the fact that please protect your intellectual property. Then as a student, you can simply ask, okay, what is intellectual property? And then I will get to the point that why you should protect it. First, I am going to tell you what is intellectual property. One figure is there on the screen. You can see there is a car, there is a building, there is a plot, land. That is not an intellectual property. These things are your physical, tangible assets, physical properties, the properties that you can touch. These are the, for example, if you have a piece of land, that is your property, and maybe you are using that particular land for your own sake, but then some other person comes and he says, no, I want to use this land. What do you say to that person? You cannot use it because I have the registration in the name of this in my name or this particular land. So what happens? The government gives you the ownership for the physical properties. And when you show this ownership, that registration to the person who want to use your property on his own will, you show that registration and that person cannot use it because this is in your name. Similarly, if you are creating any intellectual properties, in intellectual property if you are creating, then the ownership can be given to you in your name. Similar as the case of physical properties. This session is not about the physical property. This session is about the intellectual property. But similarity is that the way the physical properties can be protected in your name, in a similar fashion, the intellectual properties can also be protected in your name if you have created some intellectual property. Now the question is, what is intellectual property? Any property, just one-liner definition you should remember. Any property that you create using your intellect is your intellectual property. Okay, like suppose you are good in writing, you are writing a poem, that is your intellectual property. You are writing a novel, intellectual property. You are drawing something, sketching something, that is your intellectual property. You are inventing something, that is your intellectual property. Okay, so these things are your intellectual property. So any property that you create using your intellect is your intellectual property. And there is a photograph in the middle of this particular screen. There is a photograph and there is a chameleon. I had taken that photograph a few months back in my office premises. That is my intellectual property. So even a photograph that you have taken is your intellectual property. So any property that you create using your intellect is your intellectual property. And there is a whole legal framework in the country which is going to protect your intellectual property in your name. Now you will ask, you can simply ask, why should I protect my intellectual property? So first thing, I told you that what is intellectual property. And then I'm telling you that you can protect your intellectual property in your name, and the protection is given to you by the government of India, by the central government. Now you will think, okay, what is the benefit of the protection of my intellectual property in my name? Why should I protect it? What would I get if I protect my intellectual property? The answer is this. If you protect your intellectual property, and as I said, that intellectual property can be anything. It can be your novel, it can be your poem, it can be your invention, it can be your drawing, it can be your sketching, it can be your photograph. Any property that you create using your intellect is your intellectual property. And if you protect it, what you would get is this. One is commercial exploitation. The right of commercial exploitation of your intellectual property goes to you only. No one can if you take the protection in your name for the intellectual property that you have created, no one can exploit your work commercially without your permission. That is one very important benefit. Another benefit is that recognition. And this is also very important. Suppose you have been given some trademark from our office. So that recognition is there by the government of India that, okay, this trademark is yours. Suppose you have been given some patent rights in your name. So we are going to give you one certificate. As an applicant, your name is there. So you are now the owner of that patent right. So that recognition is there by the government of India. So that recognition is also there. So once you protect your intellectual property in your name, the protection is given to you by the government of India, and the benefits are twofold, and these both of them are very important. One is right of commercial exploitation, that is your right now, and another is recognition. So this, and that is going to be a huge benefit to you if you are given these two very important rights in your name. Like for some person, for some people, commercialization of the product matters a lot. They want to commercialize the product. Okay, but for some people, pride, recognition matters more. The beauty of intellectual property rights, those are given to you, is that it gives you both the right of commercial exploitation plus the recognition or the pride. Okay, so intellectual property rights, those are given to you, give the huge benefit. Now, I gave you many examples, like what are the things that can fall into the intellectual property definition. I told you poem, writing, your literature, your painting, your invention. Suppose you are interested in some design of ornaments, that is also your intellectual property. So intellectual properties are actually, all of these are classified into mainly in these 6 sections. So this is a very clear classification of intellectual property. Many of the times what happens when we take some program in some institute and we say that, okay, we are going to take a session on intellectual properties, then the first impression that is there among the students is that, okay, sir is going to take a program on patents. We want to tell you that patent is not the only intellectual property. Patent is very famous, no doubt. Patent is very famous intellectual property, and patent is one of the most important intellectual properties. Nevertheless, patent is not the only intellectual property. There are many kinds of intellectual properties, and it is very important for you to know the classification of these intellectual properties. Some intellectual properties fall into the section of patents, but some intellectual properties fall into the section of designs, trademark, geographical indication. Copyright is also an intellectual property. Semiconductor integrated circuit layout design, that is also intellectual property. So depending upon the work you are doing, depending upon the intellectual property that you have created, one particular classification is assigned to that particular intellectual property. Suppose you have written a poem, the intellectual property rights that is associated with your poem is copyright. It is not patent. But if you have invented something, some device, in that case, intellectual property right that is assigned with that device, your invention is patent. If you have designed a bottle, if you have designed a textile design you have done, if you have designed some particular furniture, that design, that is given one particular kind of intellectual property right, and that is design. So depending upon the intellectual property that you have created, your work may be assigned one kind of intellectual property. It can be patents, design, trademark, copyright, geographical indication, etc. Now, when the students are not very clear about this particular classification, then they make this kind of wrong statement. Some student is sitting in front of the officer and he is saying, all I asked was, can I patent my copyrighted trademark? This statement is funny. This statement is wrong. Can I patent my copyrighted trademark? When we get to hear this kind of particular statement, then right away we feel, okay, this student knows that there is something that is called patent, there is something that is called copyright, there is something that is called trademark. He is basically aware that yes, there is sometimes these kind of terms are there, but he is not very much aware about the classification of the intellectual property. That is why he is mixing up the things. Patent is given to this to the invention. Copyright is given to literature, drama, art, music. Trademark is given to some identity of a brand. So these things are given to different things. That classification you must know. And when you are clear about the classification of intellectual property, then you will not make these kind of wrong statements. Okay. Now, as I said, these 6 sections are there. Basically, these 6 sections are there as intellectual property, and I will be discussing one by one all of them. But mainly the patents and copyright, these 2 parts of the intellectual properties, I will be discussing in a bit elaborated manner, and rest of the intellectual properties, I will be giving the essential view about all of them. The main features I will tell. But patents and copyright, I will cover elaborately. And let us start my discussion about the classification of intellectual property with the first kind of intellectual property for today's discussion is patents. Now, being from the science background, maybe you have already heard this term patent. I already told you that patent is given to one kind of intellectual property, that is invention. So I will start with the discussion about the definition. First, only the definition, basic definition of patents. Patent is given only to an invention. So if someone says that I have written a very good book, I want a patent for that, it is a wrong statement. Patent is not given to a book. Patent is not given to a poem. Patent is not given to literature. Patent is given only and only to invention. So patent is one kind of intellectual property right, and patent is given only and only to some invention. For example, this, if you see this particular screen, I believe that many of you know this particular legend, Mr. Michael Jackson. He is making his famous dance move, and he is making his famous dance move, and this particular dance move was coined as anti-gravity illusion effect. It looks like that Michael Jackson is defying the gravity. Now the question is, how is it possible that he is tilting so much? What is the secret? It looks like he is tilting this much that he is defying the gravity. Gravity cannot be defied, but it looks like he is doing that. Now, the secret was hidden in his shoes. A normal person can tilt around 15 degree from perpendicular, just like this, 15 degree, maximum 20 degree. But he is able to tilt around 45 degree. How was he able to do it? Actually, the secret was hidden in his shoes. When he is making this dance move, what is happening? He is moving on the floor, some nail is coming out of the shoe, it is sticking to the ground, and he is tilting around 45 degree. Then he goes back to his original position. The nail goes inside in his shoes, and then he is moving again. This particular shoe, some particular application was filed for the patent rights for this particular shoe. And this, I have taken the first page of the patent application, and you can see in the circle I have circled some particular name of the inventors. What are the name of the inventors? Michael J. Jackson, Michael L. Bush, Don Tompkins. So these are the 3 alleged inventors for this alleged invention. All I included this example so that you could always memorize one thing very clearly, that patent right is given to some particular kind of invention, some device which is in working form. Okay. And now I'm going to show you some examples of basic invention, because many of the times we have feeling that students get scared. They think that patent is something which is a very far-fetched thing. Like it looks like that patent will be given to some very extraordinary, very complicated invention only. But this is not the case. It is not that the patent will be given only to a special theory of relativity experiment or general theory of relativity experiment, something very complicated. It is not the case. Patent right can be given to the simplest inventions as well, given that this particular invention satisfies some particular criteria. I will discuss that criteria also. But for now, I'm going to show you a few examples which can tell you that the patents rights are given to very simple inventions also. For example, this very young child, she had invented one particular kind of house which can be very useful in the flood prone areas where there are too much of flood. What happens that in the case of flood, too much of water is rushing towards the houses, and for example, just imagine in the night some huge amount of water is getting into the houses and people are not finding a way to run away, and especially the people who are not very much capable of moving swiftly. For example, senior citizens, pregnant ladies, the children who are not very too much able to run and to get away from the water, there is a high risk of getting them drowned. So there is a lot of loss of life in the flood prone areas. So what this particular child did, she invented a kind of houseboat, you can say, that when the water is getting into the houses, what will happen that there are sensors, and what will happen that there is a zip kind of a structure from top to bottom in the houses. Sensors are there, water is rushing towards the house. Then what will happen that the zip will automatically get opened and the house will become a kind of boat and it will start floating on the water. So that is going to help to save the life. So this is very beautiful, life-saving, great invention, not too much complicated, and it was also. So I want to convey that even the simple inventions are given the patent rights. For many of the students who are available here, many of them must be playing cricket. These kind of stumps were not there. And you can see that there is a cricket player who is holding one particular stump. That kind of wooden stumps were there. They are very sensitive. The bells are getting out and the umpire is there to decide just on the basis of those lights and the stumps that whether a player is out or not. For example, when many of the students are here who know that the rules of cricket, when one bell is in one end of the other bell is of the stump, then the player is not given out even if he has not reached the crease. The condition is that the player is running toward the crease, he has just also glow in that particular moment. So the conditions are very fine, and the glowing of the stump and the bells, that is going to help the umpires to give a very fine decision. So this invention, it is not very much complicated, and even when I saw it for the very first time, I felt that even I could think of that. Why did I not think of that? Even it's a very simple invention. It is given the patent rights, and probably the one who has the patent right must be making millions of dollars. That person's permission. So even the simple inventions are there which are given the patent rights. Another example, when you are driving a bike or bicycle, what happens? Suppose you are driving a bicycle in the night, and then you are pulling the brake. Then some car coming from the back, maybe they cannot sense that you are pulling a brake, and there is a chance they can hit you. They can hit the bike rider. Or suppose you are taking a right turn or left turn you are taking, and then what is happening, that the car or any vehicle which is coming from the back, they cannot sense that, okay, you are taking a right turn, it is night, and they can hit you. There is a chance that you can be hit. In order to avoid those kind of mishappening, this particular helmet was invented, and this is also given the patent right. What is happening? This particular helmet is there. There is a right indicator on the right side of the helmet, left indicator on the left side of the helmet. On the back, there is a strip which glows when you are pulling a brake. There is one accelerometer in the helmet that can sense that, okay, you are pulling a brake, then it will glow, the back side of the helmet will glow, and the vehicle coming from the back can guess, okay, you are pulling a brake. You are taking a right turn, left turn, you can just blow the indicators. And this is also a very, very, very simple invention. This is given a patent right, and it is going to save many. And the person whose number is saved. So it is a life-saving, very simple invention. Patent will be given to something which is too much extraordinary. The invention must be extraordinary. No, it is not the case. Of course, the extraordinary inventions are given the patent right. At the same time, the simple inventions are also given the patent rights. Now, I started with the definition of patent right. First point was patent is given only to an invention. Exclusive right. Suppose you have invented something, you have taken the patent right from our office. The government of India is going to give you that patent right. Then that right is exclusively yours. You are the one who can exploit your work commercially. You are the one, suppose someone else wants to exploit your work commercially, you can stop that person, or you can assign your right of patent to some other person. But the right is exclusively yours. You are the sole deciding authority that who can exploit your work.
Hello. Abhishek sir,
Hello,
sir,
ma'am.
we can't hear you. Yes,
I think
network issue is there.
I think it was gone. Suddenly the meeting was stopped. Okay. Can you see my screen, ma'am?
Yes, sir. Now I can hear the sound also, sir.
Okay, you can see the screen.
Yes, sir.
So you can see that patent right is a territorial right, right?
No, sir. Your screen is sharing, not your PPT slides, sir.
Okay. Just a minute, ma'am. I think sharing was stopped automatically the moment meeting was gone. Can you see it now, ma'am?
Yes, sir.
Okay.
So now his screen is visible, sir.
That patent right is sovereign or state, by sovereign or state, right?
Now, yes, what is patent and
Yes,
about
yes.
that? Yes, sir.
Yeah, so in the definition of patent, the first point was it
Huh.
was given only to invention. Second point was it is an exclusive right. And third point is that patent right is given to you by the sovereign or state. And sovereign in our case is the government of India, which is going to give you that right. That is why patent right is a territorial right. I want to say it very specifically that there is nothing that is called international patents. Because many of the time students say that, okay, this device is very nice and it has international patent. No, there is nothing that is called international patent, because patent right is only a territorial right. If you want to have the patent right in United States, then you have to apply separately in United States. If you want to have the patent right in Great Britain, you have to apply separately there. If you want to have the patent rights in India, you have to apply separately in India. There is nothing that is called international patent. You have to apply separately in all the other countries where you want to have the patent rights. This is very important. That patent right is an territorial right. Now, patent right is valid for 20 years. This is very important. It is not that you will be given the patent right and it will go for forever. It is not the case. Patent right is valid for 20 years. After 20 years, your work will be a public property, you can say. Up to 20 years, you have the sole authority to decide who can exploit your work commercially. You are the owner of the patent and you will decide who is going to have the who can exploit your work commercially. But after 20 years, anyone can copy your work, produce your work, can exploit your work commercially. By that way, what happens that new inventions come to the public property, you can say, they can use it now. Okay. So life of patent is 20 years. You should mug up this. Now, I'm going to give you one simple invention, one simple example from where I can show you 2 or 3 things. One point is that a simple invention can get the patent right. This particular spin brush, it is a very good invention, very nice invention, but it is not too much complicated. Even this invention was given the patent right. What happened, Mr. Osher and his several partners, they invented this particular spin brush, and the best thing they did, they got a patent right for this spin brush. When they got the patent right, now it was their rights only. They can decide who is going to exploit their work commercially. So what happened, Procter & Gamble company, one of the biggest companies in the world, when they got interested in this particular spin brush, they cannot copy it. Why? Because Mr. Osher and his partners, they had taken the patent rights in their name. So now the companies cannot copy it. They had to approach Mr. Osher, and there was a deal between them. And eventually, the rights were given to this particular company in $475 million at that time, 20 years back, 23 years back. So how could Mr. Osher and his several partners how could they make this much of financial benefits, huge profit? Only because they had taken the patent rights in their name. And this also shows the power of patents. No company as big as Procter and Gamble, even they cannot copy it, snatch it. Any company, it's illegal to steal the product on which the patent has given to someone else. Similar example was this Coca-Cola can, this particular can. This ring pull can, it was given the patent right to some particular person. And when Coca-Cola got interested in this ring pull, they had to approach that particular individual entity, because that person or that individual entity had already taken the patent rights in his name. Then Procter and then Coca-Cola had to approach that particular person in order to have this particular ring pull can invention in their name. And in this time, the owner of this particular patent of Coca-Cola, the owner was he did not give the patent right, rather he gave the license. And license was, he charged 1/10 of a penny per can. And by that, he was able to 1,48,000 UK pound per day. So how could he do it? He could do it only because he had taken the patent rights. So that is why we keep on emphasizing that patent right is very important. It is very strong. It is very powerful. Please take the patent right for any invention that you have created. Please take the patent right in your name. But if you are applying for the patent rights, please do not publish your work before filing the patent application. This is very important. Very important, because you can see all these three phases, and all these three phases are there. They are saying, I should not have published before filing. Suppose I'm going to give you some example. You are a student of BSc first year or second year or third year. You are inventing something, and your invention is very smart, very nice. Your father get very happy, and some journalist from the newspaper, he contacts your father, and he says, okay, your son has or daughter has created this particular invention. It looks very nice. What it is? And your father or even you tells everything to that particular journalist, and the whole structure gets published on the newspaper. In the newspaper, what will happen? Now it is in the public knowledge. What will happen? And then you choose, okay, now I have published in a newspaper. Now let me apply for the patent right. You write a patent application. That patent application comes to me. As an examiner in our office, some examiner will examine your work. That examiner will try to find out some work which is already published, and that is similar to your work. In the process of searching for the document which is similar to your work, he might come across the particular article given by your father or by you in the newspaper. And if it is published before you filing the patent application, that examiner can simply cite that particular article, and based on that particular article, you getting the chances of the patent right will be killed. And this is very serious. Anything that has been published before you filing the application, before the filing of the patent application, if you have published it somewhere, that things can be cited as the prior art document, and your own work can get cancelled based on that particular your application. You cannot be given the patent rights based on that particular earlier publication. So it is very important that you publish your work only after filing the patent right. This is very important. And however, there are some exceptions to that. There is some section in Patents Act 1970, which is already available in IP India website that I have told you in the beginning. Section 234, there are some things which are written where it is the discretion of the controller to decide whether some grace period should be given to you or not. Your work is already published, and then you come for the patent filing. then we go through your patent application, and then we get to know that, okay, your work has been published somewhere. So in some exceptional situation, we can make decision that, okay, we are going to give you 1 year of grace period. If within that grace period you have filed the patent application, it is all fine. But generally speaking, it is the discretion of the controller, and it is depending upon the situation whether you should be given that flexibility or not. So in order to be at the safe side, please make sure that you publish your work only after filing the patent application. And this is another very famous story in which that kind of blunder was done. Mr. Milstein story. In 1975, Mr. Milstein gave a very great presentation on monoclonal antibodies, very original work, very new. And his work was published in the journal Nature before filing the patent application. And that was the blunder. He filed his work in such a eminent journal, Nature, before filing the patent application. He published it. And what happened? Just on the basis of that publication, his patent application was rejected. And he was such a pioneer scientist, such a great scientist. In 1984, he got the Nobel Award along with Mr. Kohler. So his originality cannot be questioned. His invention was actually an invention, but rule is rule, law is law. Based on the earlier publication that he has already published in Nature, he was not given the patent right. And there was a huge political uproar in Germany. The government got shook and everything happened, but he was not given the patent right. In the future, when he was asked by someone that whether he was sad that he was not given the patent right at that time, Mr. Milstein said, no, I was not sad. Miss Thatcher was sad. He is referring to Miss Margaret Thatcher. The point is, he was definitely very generous, and that he was not sad. But technically speaking, he missed the patent application, patent rights, and probably the millions and billions of dollars also. So this blunder must be made. Please do not publish your work before filing the patent application. If you want to publish it even after 1 day of filing the patent application, that is fine, but not before filing the patent application. Now you might think, okay, how to file it? How to file the patent application? So we have given many options to all the applicants. You can, if you want to submit the hard copy, you are most welcome to our office. Delhi, Mumbai, Kolkata, Chennai, our branches are there to accept the patent application. You can come to our office. You can submit the hard copy in the office directly. If you are unable to come to our office, it is very far from your house, then what you can do is that you send it to us by post. If you don't want to send it to us by post, or you don't want to come to our office, then you can go for e-filing. And I told you in the beginning that there is website ipindia.gov.in. That website you open, and then you can file. You can find some places there. E-filing is there. E-comprehensive filing is there. You can upload your documents over there along fees and some forms. And these forms are also, I'm telling you, these are not complicated. And one thing I want to tell very particularly, that you can submit your patent application on your own in the individual capacity also. I want to specify that because we keep on taking the programs in many institutes, and we have felt that many of the time professors and faculties and even the students have impression that they cannot do it on their own, and patent agents or some third parties are important. They are mandatory to file the patent application. It is not the case. You can submit your patent application in the individual capacity also. Okay, in your own individual capacity, you are allowed to do that. You can do, you can definitely do it. Okay, and it is not very complicated also to submit the patent application. You can see there are just 5 forms, and these are very simple forms also. And let me tell you that even if you make some mistakes in filling the forms, in writing applications, we are here to support you. We are here to help you. You can say that our office is one of the most applicant friendly office, I would say. If you are making some mistakes, we would tell you in our report. When we send the report to you, we write that, okay, you have made some mistakes. You have not put your signature over here. You have not submitted form 5. You have not submitted some particular form. We will tell you your mistakes. It is not that we will keep your form aside if you have made some mistake. Okay, so some simple forms are there. We are going to help you also if you have made some mistake. Form 1, Form 2, Form 3, Form 5, Form 18. These 5 forms are very important. Form 1, simple, your details. Like you are filling some school form, you write your name, application, nationality, address of service. Those things are there. Form 2 is only your work, what the work you are submitting. That is Form 2. Form 3, you will tell whether you have filed your application in some other countries or not. Form 5 will tell that, okay, you are the applicant, who is inventor. About the inventorship, you will write. Form 18, if you want to examine, definitely that is a must for patent decision or patent examination. You have to submit Form 18. So these are 5 basic forms. Okay, so you can simply submit your application or your own on your own in individual capacity. And if you are qualified to write a patent application, if you are qualified to write a research paper, if you are qualified to write a dissertation thesis, if you are qualified to write a BSc project thesis, BTech project thesis, then you are far more qualified to write a patent application. It is not very much complicated, I'm telling you. Okay, so you will submit these forms through this mode, online or offline, that is your choice, with this fees. Fees is also, you can see that if you are a natural person or you are just a startup, you are a small entity, or you are an educational institute. These things goes for you. If you fall on in these things, then this form, the fees is written over here. For Form 1, the fees is 1,600. For Form 18, the fees is 4,000. So if your work is within 30 pages and claims are within 10 or within 10 claims, then the fees is only 5,600. Okay, 5,600. That is the fees if you are a natural person or a educational institute or a startup or a small entity, and your work is within 30 pages and the claims are 10 or less than 10, then your fees is only 5,600. But your pages can go even over and above the 30 pages, and the claims can be more than 10 claims. It is just that per extra claim, per extra page, you will be charged some extra fees. That is it. Okay, there is no upper limit to the number of pages. There is no upper limit to the number of claims. So this is the fees structure. First column is your fees structure. Okay, so this fees, these forms, this method, and your work will be streamlined for examination, and in the queue it will come to us and we will examine it. Okay, so I have covered the patent section elaborately, and now the first kind of intellectual property, that is patent, for today we have covered it elaborately. Then I'm going to cover the second kind of intellectual property, is design. I will not get into the much deep of this particular intellectual property, but I would definitely give you the gist of the meaning of the design registration. How do we do it? Some basic essentials I will definitely cover. Now on the screen you can see that there are different kind of bottles, shampoo bottles, the different shapes and sizes are there. Actually, these particular designs are also given the design registration. If you are interested in adding some aesthetics value to some product, that can be given the design registration. This particular shape, size, these are given the design registration. Design registration is also a kind of intellectual properties, which is given to the some aesthetic aspect applied to some particular shape and size, applied over some article. Now, what happens that designs are going to attract people. when they are attracted to the design, they buy it. So by adding the aesthetics value to some article or to some product, designs are going to add commercial value to the product by adding the aesthetics value to the product. Okay. So, for example, suppose some child is there. What happens when children's they enter to some cycle shop? They had their own idea that okay, some particular shape, size they want for the bicycles. More or less, all the bicycles are going to serve the same purpose. But children are very much particular about the particular design of the bicycle, and they will buy that bicycle only towards the particular design they are attracted to. So even if the functions are same, the design is going to add the children. Similarly, the wristwatch. All the wristwatches, mostly, more or less, they all have the same functional purposes. But when you are going to buy the wristwatch, the first thing that you notice, what is the shape, size, and the design. So designs are going to add the commercial value to the product by adding the beauty, by adding the aesthetics value to the product. When I bought this particular pen, why did I buy this? I did not buy this because it was running good, some flow was there, or some grip was good. No, I did not buy this for that reason. I bought this 7-8 months back. I bought this pen only because I was attracted to its shape and size. I was attracted to the aesthetics value of the pen. And when I bought this pen, the reason was the judgment by my eyes, that how is it looking. So I was attracted to the aesthetic value to this particular product. And please mind it that this is also the sole criteria of the judgment of the design registration to the particular design by the examiner or by the office. So office, when it is judging some particular design, that whether the design registration should be given to this particular design or not, the office will also make the judgment just on the basis of the particular basis of the judgment by the eye. Functional aspects are not taken into consideration. This is very important. Functional aspects of any designs are not taken into consideration by the office when the design registrations are being judged, whether it is to be given or not. So if you have invented something, if you have made some device which is having some functional aspects, some particular designs, some functional aspects, some particular aesthetics value, then what you can do is that you can file the application, both applications, like patent applications also, for the functional aspects of the product, and the design registration also for the aesthetics value of the product. And you have to do it within a limited period of time. So in a short span of time, you have to go for the application for the registration, or in the patent section also, for the registration in design section also, given the situation that the product has both of the things. The aesthetics value are also there, and also there is some functional aspect. So if your product does not have any functional aspect, then please apply for the design registration. If your product does not have any aesthetics value, only functional aspects of is there, then you apply for the patent application. But if your product has both things, functional aspect is also there, design aspect is also there, then you apply for patent also and design also for both of these intellectual properties. Now, as I said, you can be interested in fashion designing, you can be interested in textile designing, you can be interested in ornament designing, you can be interested in utensil designing, you can be interested in furniture designing, you can be interested in any kind of designs. If you are good in designing things, adding the aesthetic value to the product, then you can apply for the design registration for your particular design. For example, this particular boy, Mr. Hridayeshwar Singh Bhati, he was very much interested in this particular, this is a circular chessboard. He got interested in this kind of design, and he designed this particular kind of chessboard which can be played by 6 people together. in a pair of 2 or in a pair of 3. And when he designed it, this particular design was given the design registration in India, way back. And at that time, he was the youngest till date to have the design registration. And he got many awards. In the future also, he kept on modifying his design and he kept on working on that, despite the fact that he was suffering from one very serious disease, that was Duchenne muscular dystrophy. Unfortunately, we lost this young boy 2 years back because he had cardiac arrest, and because of the complications of his health, the earlier complications, it was already there. But despite the suffering from these kind of serious things, he kept on modifying his work. He kept on applying his intellect. And that is why we respect, like our office is Intellectual Property Office. And we are definitely here to respect, appreciate all the people who are going to use their intellect. And this boy is respected not by the masses in general only, but also by our office, because he was the intellectual winner, right? Now, how do you apply for the design registration? I have already told you that how do you apply for the patent application. Now, how do you apply for the design application? Again, you have to submit just one form. In patent, there were 5 forms. In design registration, you have to submit just one form. Point 2, you can see application form 1, you have to submit, along with mentioning some class, the class under which your application, your work is falling. You have to submit some fees. Fees is also written on the top, and 2 set of representation sheet that you take many pictures of your design that you have created, and the number of pictures should be such that a person should be able to imagine your work in 3 dimensions. Generally, he should be able to imagine your design. He should be able to understand your design. He should be able to imagine it. So these 2 set of representation sheet along with some fees and some form. You submit it online, offline. I have already told you the way how do you do it for the patent, the same way you do it for design. And I told you that for the design, for the patent, the life was 20 years. For the design, the life is 10 years. 10 years, for 10 years, it is your right. So, and also, if you want to seek extension, you can extend it for further 5 years. So subject to the extension, the life of your design can be 10 plus 5 years. Life of patent is 20 years. Okay. So we have covered 2 intellectual properties, and first was patent, second was design, and third now I'm going to cover one of the most important intellectual property, that is copyright. Especially because you are from the world of academia, copyright is very important for you, and that is the reason why I have covered the copyright. I'm going to cover the copyright in a bit elaborated way. Copyright is like patent is given to invention. Patent is one intellectual property right that is given to inventions. Design is another intellectual property right which is given to design. Copyright is another intellectual property right, but this is not given to just one thing. It is given in 6 sections. Literature is given copyright. Drama is given copyright. Art is given copyright. Music is given copyright. Sound recording is given copyright. Cinematographic films are given copyright. So copyright protection are given into 6 sections together. Patent is given only to one thing, that is invention. Design is given only to one thing, that is design. Copyright is given to 6 sections: literature, drama, art, music, sound recording, movies. Now, if you are interested in writing a book, you are interested in writing a poem, then you are given the copyright protection in literary work section. So many of you, as a professor or even as a student, many of you may be interested in writing some literature. And that literature can be poem, that literature can be a book on quantum mechanics. That literature can be anything that you write. So that literary work, so that work is given copyright protection under literary work section. And if you are good in painting, if you are good in taking photograph, those things will be given the copyright protection under artistic work section. you can be given the copyright protection from your drama and the dramatic work section. If you are good in composing music, your composition will be given the copyright protection under musical work section. So depending upon the work you are doing, your work can be given the copyright protection under some particular section: literature, drama, art, music, sound recording, movies. Okay, so in 6 sections copyright protection is given. For example, when I took this photograph, in the background you can see there is a photograph. When I took this photograph, I took it a few months back. I am the copyright owner of this particular photograph. Okay, so the question is, now I'm going to discuss one very important thing with you. There is something that is called ownership. There is something that is called authorship. Okay, the copyright protection is given to the owner. Okay, owner of the work. For example, when I took this photograph, the question is this: who is the author of this photograph? I am the author of this photograph, and I will be given the copyright protection under the artistic work section. Okay, so I am the author of this particular photograph. Now the question is, who is the owner of this photograph? Well, in my case, I am also the owner of this particular copyright associated with this particular photograph. But suppose I would have taken this photograph under some job obligation by any channel, by National Geographic Channel, by Discovery Channel, for example. Suppose if I would have taken this photograph under some job obligation by someone, then I would still be the author of this photograph, but I would no more be the owner of this particular photograph. And this is very, very important. If I'm doing some work, and this concept is extendable to all the 6 sections of copyright. If I'm doing some work in which I can be given the copyright protection, and if I'm doing that work under some job obligation, I am being paid for that, then I will not be the owner of the copyright associated with this particular work. I would be the author of that work, that is fine, but I would no more be the owner of that work. And this is very, very important, because the copyright is that right goes to the owner only. And this is very important. If you are writing a book, and if you are writing a book under some job obligation by the by your institute, if they are paying you for writing that particular book, then they will be the owner. Okay, and this is very, very important, that you must know that whether you are owner or not. If you are doing it on your own will, you are writing the book on your own will, and you are not being paid for it, then you are the owner, you are the author. But if you are doing under some job obligation, then you are the author, you are not the owner. Okay, this is very important, because many of the times people feel cheated, because suppose I mean, there are many cases, and there are a lot of cases which are fought on that basis only. Just make sure, if you are writing, you are creating some intellectual work in which you can be given the copyright protection, then make sure that if you want the ownership of that particular copyright, then make sure that you are not doing it under any job obligation. This is very important. Okay. Now, this is the last concept I'm going to discuss on copyright, and this is very important, that there is something that is called idea expression dichotomy, and I will make you understand through one of the examples. One line it is written over there is copyright cannot protect an idea. This is very important. Copyright cannot protect an idea. Idea can be copied. Okay. Subject matter can be copied. Expression cannot be copied, because copyright protection is given to expressions. Expressions cannot be copied. This is very important. For example, this particular case, there was one famous play, Hum Hindustani, that was by Mr. R.G. Anand. And what happened in 1978, the outcome of this case came. What happened? Someone, as claimed by Mr. Anand, someone from Deluxe Film, they contacted Mr. Anand. They said that, okay, your play is very nice. We want to make a movie based on play, that is Hum Hindustani. Based on that particular play, we want to make a movie. Mr. Anand said, well, fine, if you want to make a movie and if you want to discuss, you can discuss. I don't have any problem. As claimed by Mr. Anand, they contacted Mr. Anand, they visited Mr. Anand, they discussed the plot of the play with Mr. Anand, and then they went back. After they went back, they wrote back to Mr. Anand that they are no more interested in making a movie. Mr. Anand said, well, fine, you have already discussed the play, but since you have already discussed the play, but since you don't want to make a movie, what can I do? It okay, don't make, not a problem. After some time, as claimed by Mr. Anand, after some time when he came across this particular movie, New Delhi, it came to him as a shock because he felt that this movie is a clear copy of his play, Hum Hindustani. He went to the court. In the court, he said that, my lord, you should stop this because this movie is a clear copy of my play, and they had already discussed the plot. After going through everything, after going through hearing and everything, court said this, that we cannot stop this movie. The reason is that if they have copied the plot only, it is fine. They have not copied the expression. Copyright protection is given only to expression, not to the plots, not to the idea. Anyone can copy the idea, anyone can copy the basic plot. They cannot copy the expression. So that was the decision by Supreme Court. No one can copy the expression, but historical facts can be copied, plots can be copied, subject matter can be copied, idea can be copied. For example, suppose someone wants to make a movie on Talikoti War. I'm not sure how many of you have heard this particular war, Talikoti War. I think it happened in 1655. What happened in this war? Vijayanagar Empire got demolished completely. Eventually, finally, it was demolished. So if someone wants to make a movie on that particular historical fact, they can simply make it. They don't have to take the permission from another person who has already made the movie on the Talikoti War in the earlier. Because historical facts can be copied, it is all fine. But you must not copy the expressions. You cannot copy the forms. You cannot copy the manner and arrangements. Okay, so that is the idea about the idea expression dichotomy. Okay, now I believe that this particular slide is going to encourage you a bit if you are planning to write a book, because you will see that the copyright is actually a bundle of right. If you are given the copyright protection, you will be given the bundle of rights. It's like for example, suppose you have, with one example, I'll go ahead. I told you that copyright protection is given in 6 sections: literature, drama, art, music, sound recording, movies. Okay, I am going to discuss just first section. For example, suppose you have written a book, a good book on quantum mechanics. You have written a masterpiece. You will be given the copyright protection under literary work section of copyright. Now, if you have that particular right, and under the copyright, you will have the right of reproduction. If someone wants to reproduce your book, that person will have to take your permission. That entity will have to take your permission for reproducing the book. But then someone tells you, sir, I want to translate your book. I want to make some derivative work of your book. I want to translate it. Then that person will have to take the permission from you. Second entity that will have to take the permission from you for translation. But then someone third entity contacts you, and that person, they say, sir, I want to distribute your book. Then what you will do? You will give your right of distribution to that particular person, the third entity. Then fourth entity comes. He says that, sir, I want to do some communication to the public of your work. I want to do it. I want your permission. Fourth entity will also have to take permission from you. Then someone says, I want to do public performance based on your book. That fifth entity will have to take your permission. So all these entities, 1, 2, 3, 4, 5, 6, 7, all these entities will have to take your permission. And you will give those rights to these 1, 2, 3, 4, 5, 6, 7 entities because you are given that right. Okay, you have those rights, and then you will give that permission, give those rights to all these 1, 2, 3, 4, 5, 6, 7 entities, and you will take the royalties based on your mutual discussion. You will take the royalties from all of them separately. So you can see that how many rights are there under copyrights. Too many of rights. It's a bundle of rights, and you assign all those rights individually. You can assign to separate entities, and you can have the royalties from all of them. Okay, so copyright is actually called a bundle of right. Now, last slide of copyright is, it is life of patent was 20 years. I told you the life of patent was 20 years. Life of design, it was 10 years. Life of copyright is very interesting, very nice. It is for literature, drama, art, music. It is life of author plus 60 years. This is very interesting. Suppose you have written one particular masterpiece, one particular good novel, one particular great painting, you have created one great music you have composed, then your rights will be up to your life plus 60 years. That means generations to come also can can have the royalties based on your own work. So the life of your work is, you can say it's right of your work is, the life of copyright is actually very fascinating. Life of author plus 60 years for literature, drama, art, music. For sound recording and movies, it is 60 years from the date of release. Okay, so first two rows, these two rows show you the term of protection or the life of copyright. Okay, life of patent, I have told you 20 years. Life of design, it is 10 years. Life of copyright, it is available over here in the first two rows. Bottom two rows are not the copyright like rights. Broadcasting right, performance right, these are having separate term of protection. Okay. Now, fourth intellectual properties that I'm going to discuss today is trademark, and you can see what is wrong here. What is wrong here? Abibas, you can see on the screen, it is written Abibas, then it is written Pespi, then Poma, Besbury, and the most interesting is Coolgate. What are these? These are clear case of copyright violation, trademark violation. Trademark is the identity of the brand. Adidas is a very famous identity. Someone copied Adidas and as Abibas, Pepsi as Pespi, Colgate as Coolgate. So you already know, like if you are you already know that trademarks are the identity of the brand, and there are many cases. If you go to the different places in Delhi and any place, there are a lot of cases where we can see that there is a trademark infringement, and there is a definitely legal framework which is going to help you if your trademark is violated. Now, what is trademark? Just the basic definition: trademark is identity of the brand. And if you want to, suppose you want to go for a startup in the future, then you want to have your own trademark for your startup. What will happen? You will make some particular logo or some invented word, and that is your identity of brand. So that is your choice. You can use some invented word, you can use some dictionary word arbitrary, you can have some numerals, you can the combination of the dictionary word and the invented word and the numeral, that can be your trademark. Shapes can be your trademark. Sound marks are also there. Okay, in some countries the smell marks are also there, trademark, but in India we don't give smell mark, but sound mark, shapes, some shape, size, those things are your identity, can be your identity of brand. And you can see on the bottom, it is Columbia Pictures. It is that there. If you have seen some Hollywood movies of Columbia Picture, you can see some particular sound comes, and that particular sound, that is also given the sound mark as trademark. Okay. And companies are very much particular about their trademark. This is one fact that I'm going to tell you, that trademark registration is not mandatory in India. Despite that fact, I mean, you can have your own trademark by the way of the practice in the market and by making your own reputations. But like, registration is not mandatory. Despite that fact, we keep on repeating that please take the trademark registration in your name, because in long run it can cost you dearly. I will tell you how. But for now, you should know that companies are very much particular about the trademark. And they are very much particular because that is the identity of their brand. You see this particular example, that this sign, this infinity sign, and then Meta, that particular whole thing, that is also given the trademark registration. Actually, this particular shape sign was having some financial company was there in United States, and this particular trademark, this particular name was there with them only. But then Facebook got interested and they wanted this particular trademark. They contacted that financial company, some regional banking company was there, and they sold only this trademark in $60 million. You can see how much Facebook was particular about the identity of the brand, how much it was particular about the trademark. Companies are very much particular about the trademark. You know him, Mr. Elon Musk. The name Tesla Motors, he is the owner of Tesla Motors. That name particular, the trademark of that particular name was not with Elon Musk initially. It was not with him. It was actually with originally it was only with some other person, and that person was not much interested in selling that trademark Tesla Motor to Elon Musk. But then Elon Musk was very much particular. He requested him a lot, but he did not budge off. He did not give this name to him. So he sent one of the nicest guy of his office to meet that person, and he kept on requesting. And eventually he sold that Tesla Motor trademark in $75,000. Okay. So companies are very much particular about the identity of their brand, that is trademark. Now, final thing I wanted to discuss about trademark, because in future, if you are going for a startup or anything, that brand, if you are creating, please make sure that you take the registration from the government of India, from us. Please make sure that you take the registration in your name for the identity of the brand, for your trademark. Please take it. I am repeating the same concept that I told like a few minutes back, that trademark is not mandatory. Trademark registration is not mandatory in India. You can have your own trademark in your name by the way of the practice in the market and by making your own reputation. Still, despite that fact, we keep on repeating that please take trademark. The reason is this. Suppose I am making a good quality t-shirts. I am making good quality t-shirts in Delhi, and my product is getting famous now. This is now famous in Delhi, Rajasthan, UP, Haryana. It is getting famous and famous with time. I am getting a popularity. My t-shirts are getting popularity. What will happen after, suppose 6 months after, or after 1.5 years, when I have made a very good market in the North India, then I get to know suddenly that someone sitting, that person is also using my trademark and he is making t-shirts. He is making t-shirts and he has taken my trademark and using him. What I will do? I will go to the court, and the court, I'll say that, my lord, you should stop that person. He is copying my trademark. And what if he starts, like, there are many reasons that person should be stopped, because he is giving the people wrong impression that they are buying my t-shirts. He is doing unethical trading. He is going to disrupt my right. He is going to disrupt my market. If he starts making bad quality of t-shirts, my trademark is going to be jeopardized, my business will gone, I will be ruined. Me lord, please stop that person. Court will say, okay, we can do something. Okay, can you show us your trademark? I will show my trademark to the court. Court will say, okay, there is some kind of similarity between my trademark and that person's trademark. And that is easy to prove. Court will compare these two trademarks and the court will say, yes, he has copied your trademark. We can stop him, but there is another thing that I have to prove. And that is to prove the geographical presence of my product, my market in Hyderabad, which is very hard task to prove, which is not easy. Sometimes it is easy. Suppose I am very famous, I am also not only in Delhi, Haryana, Rajasthan, but my product is also famous in Hyderabad. Maybe I can prove it, but it is not very much easy, especially in the cases when I'm not very much popular or my market is not there in Hyderabad. Then it is dangerous. But if I would have already taken the trademark registration in my name, in that case, in the court, I will have to prove only the point A, that is similarity. And this is very important. This is why I keep on repeating that even if the trademark registration is not mandatory in India, please take the trademark registration. In that case, in any court case, in or any situation, you have to just prove the similarity aspect, that is point 1, in any such kind of cases. You don't have to prove the geographical presence of your product in his location or infringer's location. So that is why we keep on repeating that please take the trademark registration in your name if you are planning for any brand creation. Now, just I have covered 4 intellectual properties: patent, design, trademark, copyright. These 4 I have discussed. Now I am going to discuss just 2 more intellectual properties and 1 slide each. Okay, so it's just 1 slide for next intellectual property and 1 or 2 slides for the last intellectual property that I'm going to discuss today. So this is 5th intellectual properties that I'm going to discuss for today is SICLD, semiconductor integrated circuit layout design. Okay, this is one of the intellectual property that I'm going to discuss today. So suppose, okay, there is one section in Patents Act 1970. There is one section. In that section, it is said that some things will never be considered as invention. That section is section 3. I will not make the discussion very technical, but just discussing one section of the first kind of intellectual property, that is section 3 of Patents Act. In that section 3, it is written that some things will not be considered as invention. For example, computer programs per se will not be considered as invention. So patent will not do them. But intellectual property right is still there for the computer program, that is copyright. Similarly, there is another subsection in section 3, that is topography of integrated circuit will not be considered invention. So if there is integrated circuit topography, that will not be considered invention for the sake of patentability. But it does not mean that topography of integrated circuit is not intellectual property. Topography of integrated circuit is also intellectual property, and the intellectual property right that is associated with the topography of integrated circuit is SICLD, semiconductor integrated circuit layout design. So if there is a layout design of semiconductor integrated circuit, then that particular design is given another kind of intellectual property that is called SICLD. Okay, so that particular SICLD, suppose there is a laptop. There is a laptop. In the laptop, there is a motherboard. In the motherboard, there are different circuitry, multiple circuitry elements are there. Capacitor, op-amp, transistor, what is not there? Too much circuitry elements are there. So that motherboard is there in some particular fashion, some particular design is there. That particular design of integrated circuit is given the SICLD, semiconductor integrated circuit layout design registration. These are not given patents. These are not given copyright. These are not given design. Okay, so this is a separate kind of intellectual property, SICLT. And our final intellectual property that we are going to discuss today is geographical indication. Okay, a geographical indication, one example I'll tell you. Suppose, I'm not sure, many of the times you will come across the news where you will find that, okay, this particular thing has been given the geographical indication tag or geographical indication sign. Tirupati Laddu has been given the geographical indication tag. What is that geographical indication tag? And what are the products which are given that particular geographical indication tag? So the answer is this. Suppose there is some product which is having some specific geographical origin. For example, Darjeeling tea. It has some geographical origin, specific geographical origin. Or suppose Tirupati Laddu, or suppose Kanchipuram silk. So those things have some particular geographical origin. And the quality is because of that particular origin. And if not quality, then the reputation is because of that particular origin. Then that thing will be given the geographical indication tag. For example, Darjeeling tea is there. That Darjeeling tea is having some specific geographical origin, and also it has the quality because of that particular climate. And if not quality, then at least the reputation is already there. Definitely the reputation is because of that particular origin, that okay, this tea is from Darjeeling. So if a product has these two quality, okay, that it has some particular geographical origin, okay, Kanchipuram silk has some particular origin, and it has the quality or reputation because of that particular origin. Kanchipuram silk has a reputation because of that particular origin. Okay, then that product is given geographical indication sign by the government of India. Okay. For example, now the question is why? What is the benefit? Final question is, what is the benefit? Why should geographical indication sign is given? I mean, what is the benefit if some product has the geographical indication sign? The answer is this. There is not just one, but there are many fold advantages. Suppose some geographical indication that Darjeeling tea, that geographical indication given to Darjeeling tea, then what will happen? That if someone is using that logo on some Darjeeling tea, some tea, then you rest assured that okay, this is actually a Darjeeling tea. It cannot happen now. A tea seller who has taken a local tea and that person can use Darjeeling tea logo on that and now it can sell it. No, it cannot happen now. Okay, so this logo is there to confirm that yes, it is actually authentic Darjeeling tea. When that logo is there, then what will happen? That there would be a kind of confidence among the people, among the consumer, that yes, I am buying the authentic product. When the confidence is there inside a customer, what will happen? He will order more. When he will order more, the economy will flourish. Okay, not only that, not only the authenticity, but the unethical trading is also stopped. And not only that, also cultural propagation is there. For example, Madhubani painting is there. If there is a logo of Madhubani painting on a painting, then I am confident, sitting in Chennai, I am confident, okay, this painting is from Madhubani painting. This is actually a Madhubani painting. Then what will happen? I will buy it. And definitely when I'm buying a Madhubani painting from all the way from Madhubani to Chennai, the cultural propagation. So cultural propagation is also there. Further, additional benefit is this, that now the money is going actually to the authentic trader, because now the actual trader who is making this painting or actual person who is weaving this sari, they are getting the money is directly flowing to them. So now the honest person is being rewarded. The actual producer is getting the money. So there are not one, but many-fold benefits of assigning geographical indication to to uh, associations which are having the geographical indication sign. Now summarizing, these are the lives. You can, I will also share this PPT with ma'am, and you can have the presentation from ma'am. There you can see all the discussion that we have made today about the life of the patent, of the intellectual properties, about the way the filing is done. Everything is there. I will share that now. Eventually the final slide, you can see that if some device is there, I mean, intellectual properties are all around you. My session today, it was about the introduction of the intellectual properties. So after giving the whole introduction, now I can safely, now I feel that I can safely tell that yes, intellectual property, you can have the confidence that intellectual property are all around you. Even if there is a laptop, on the laptop there is LED display. That is a kind of invention. So intellectual property that is associated with the LED display is patent, because intellectual property right that is associated with the invention is patent. Body of the laptop, it is adding beauty, it is giving the aesthetics value to the laptop. Intellectual property right associated with the aesthetics value or the design is design registration. Intellectual property that is associated with the identity of the brand is trademark. Intellectual property that is associated with the user manual is copyright. Intellectual property that is associated with the layout design of the integrated circuit is SICLD. So all I mean to say is that intellectual properties are all around you. These are all around you. You just have to be careful. You have to just pay attention, and you will see that intellectual properties rights are all around you. Now these are our offices: Delhi, Mumbai, Kolkata, and Chennai, where we are accepting the applications, where we examine, we make judgments. These are central government offices. And RG NIIPM Nagpur, that the bottom mid, that photograph, that is the training institute where different kind of trainings on intellectual properties are conducted. You can definitely visit the website. You can search on Google RG NIIPM. You can have some training from there if you want. And if you have any doubt, please do not hesitate reaching out to us on these numbers. You can take a screenshot. Anyway, I'm going to share the slides with ma'am and you can take it. These numbers, you can call us, you can reach out to us anytime. The email ID is there. You can write to us. Website is there. You can visit and you can be informed about intellectual properties. Recently, there has been vacancies also for the post. Like I'm discussing it because definitely I feel that you should be aware that career aspects are also very nice in intellectual properties. So in central government offices, some vacancy is also there for the post of examiner. You can just search it on Google. Examiner notification, CGPDTM, Honorable CGPDTM is there, and you can just search on Google about the notification of the examiner post. Okay. So you all will be given this kind of certificate, a modified version, which looks a bit better. And all of you will be given this kind of certificate on the behalf of Government of India for the participation. Institute will also be given the appreciation letter from the government. And thank you so much. Thanks a lot. Thank you.
Thank you, sir, for giving detailed information about IPR. Now the session is open for discussion. Here I request participants to share your opinion about the session. Here you can share your opinion. If anybody, you can share the opinion about the session. Is there anybody to share your opinion about the session?
Hello, madam.
Okay.
Hello.
Yes,
Yes.
I can hear you, ma'am.
Yes. Okay, fine. So myself, Dr. Girija from KCP College. So I want to give the today's session feedback, ma'am.
Okay.
ಸೊ ಆಕ್ಚುಲಿ ಮೊದಲನೇದಾಗಿ ಶ್ರೀ ಕಾಸ್ಕತೇಶ್ವರ ಸ್ವಾಮೀಜಿಯವ್ರ ಪಾದಾರವಿಂದಗಳಿಗೆ ಅರ್ಪಿಸಿ. So today a very warm good afternoon all. So respected principal sir, IQAC coordinator and staff, and the special the organizers. So Dr. Kashinath Desai sir, and respected all staffs. So today's session, it was on the fundamental of IPR. So in this today we'll sir explain very nicely. So sir has explained so many things covered. So what are the patent, how we can design the copyright and trademarks, and semiconductor device, and what is geographical indication. Sir explained very nicely. So and especially sir has some slide number 33 in that form number 1 to 18. So it was very super nice, sir, what you explained. We are very much easily understood the concept and all things. So surely we can apply the patent shortly, sir. Actually, we are working on this. That Desai sir and me, we are working some work on this, sir. Some still it is not in, it is in process. But anyhow, we are on patent. We are trying, sir. So recently we can submit those all things. And the session was very much effective to the especially the newly joined faculty members and those who are doing the research, pursuing their PhD. It is very much effective. The session was very good. Lastly, I want to say thank you so much, the SK College faculty members, and special thanks to the Desai sir giving this opportunity to give the feedback for this session. And lastly, Abhishek sir, I'm very thankful to you, sir. So you are accepting my invitation from the SK College. So you are giving your tight schedule. You are giving the your session is I'm going to stay. You are giving your talk from your busy schedule also. So I'm thank you so much, sir. Thank you once again, and thank you one and all. Thank you.
Thank you, ma'am. Thank you so much. And ma'am, as you said that you are
Yes, sir.
planning, your school is planning or college is planning to
Yes, sir.
file some patent application.
Yes, sir.
I would, in every session, I ensure that I give one information very particularly, even
Yes,
if it
sir.
is repeated, that
Okay.
the fees is very less. Fees is 5,600 for the
Okay.
educational institute. I am saying
How-
it because some of the time, some misinterpretation is there that the fees
Okay.
is too much heavy.
Oh, yes, sir.
But the fees is only 5,600. If you
Okay,
have,
sir.
if your work is within 30 pages, 30 or
Okay,
less,
sir.
and number
A
of claims
page.
are 10 or less, then
Okay.
the fees is only 5,600 for online filing.
Okay,
Suppose
sir.
you want to, like, there may be chances that the pages cannot be only 30, they can be 200, they can be 50, they can be 80. So
Okay.
there is no upper limit to the number of
Okay,
pages
sir.
or the number of claims. It is just that there will be some extra fees per extra page, per extra claim. Other than
Okay,
that,
sir.
if it is just 30 or 10, the fees is 5,600 only. Point
Okay,
one.
sir. Fine, sir.
Because I went to many colleges and I felt that many of the time faculties have impression that there is hefty fees for the patent filing, like 50,000 or 60,000. It is not.
Yes, sir.
It is only
Yes, sir.
50,000. Also, another thing I want to add is that in the individual capacity, also any person can file the
Yes, sir.
application for
Okay.
intellectual property. So
Sure,
any
sir.
person in individual capacity can do it.
Surely, sir. So
Okay.
definitely, sir. And definitely, sir. So that interdisciplinary we are doing that work, sir. So shortly it is ongoing, sir. So 30 pages that we are still it is on some still little bit some errors are there. So shortly we'll complete and we will intimate you, sir.
Not only 30
So
pages, it can go more, up to 30
more
pages.
pages.
It can go
Because
external.
yes, sir. So in patent you explain that is innovation. So you are giving. So if it is primary or secondary, is it right, sir? Or you need a primary data only, sir, there?
What data, ma'am? Sorry.
So actually, so what we are doing, suppose for example, we are taking some already some people they work on that area, sir. So that we are modification in that area, sir. We are doing.
Some
Uh,
modification. So you have not filed the application so far, right?
no, sir.
Okay. So if you are
Yes, sir.
if you are working on it, you have already modified it, then you can
Yes, sir.
submit the modified also.
Yes, sir. So that is in your office. Is it that possibility is available, sir?
What I'm not getting, ma'am. Sorry, what possibility?
So actually, what we are doing our work, sir. So it is already some researcher they had did, sir. Already कर चुके हैं सर ये पेपर. So हमें क्या करे उसका next part we are doing. For example, so area is different, sir. For example, Bijapur, you can take your Delhi and Bijapur. So temperature is completely changed, sir, here.
Okay. Okay.
Yes, sir. Yes, sir. On that, we are getting some different result we are getting, sir. We
Okay.
are getting a different result. So can we
Okay.
submit that part, sir, as a patent? Can you apply?
Ma'am, definitely I should not discuss what is your work. All I'm saying
Yes,
is
sir.
that
Actually,
it-
I will
I'm
call you,
saying,
sir, after.
Huh.
Yes, sir.
yeah, we can, whatever is legally I'm allowed to explain, I will
Yes, sir.
definitely explain. Not a problem.
Yes, sir.
Okay.
Yes, sir.
Some temperature is required for your invention or anything, then yeah, whatever
sir.
legally allowed, I will help, ma'am. Definitely.
Yes, sir.
Thank
Yes,
you.
sir. Sure, definitely, sir. I will contact you I know, sir. So I will contact you. Whatever I have heard some errors, so I will discuss with you, sir. And please, you can share some suggestions, sir. So definitely, sir.
Okay.
Yes, sir. Thank you
Okay,
so
ma'am.
much,
So
sir.
we are anytime here
Thank
to help everyone, ma'am. Not a problem.
Sure, sure. Yes, sir. Thank you. Thank you so much.
Thank you. Thank you so much.
Okay, sir.
Thank you, Girija ma'am, for sharing your opinion about the session and suggesting one of the best resource persons for us. Now it's time to conclude. So I would like to request our principal, Professor R.V. Jalwadi, to give presidential remark. Over to Principal R.V. Jalwadi, sir.
Respected resource person, Mr. Abhishek Singh ji, Assistant Controller, NIPAM, New Delhi, Chief Patron, Sri V.C. Hiremat, Chairman, VB Sangha, Talikoti, dear delegates, organizing committee members, IQC coordinator, faculty members, students, ladies and gentlemen. At the outset, I thank Abhishek Singh ji for his valuable knowledge sharing with all of us. Sir, special thanks to you. Sir, while elaborating things, we have quoted about Talikoti War,
Yes.
War, which held in the year 1565. It is our native place. Sir, very happy, sir. You have elaborated various things regarding knowledge of intellectual properties. Today, not only faculties, but also students should aware about the intellectual property rights. I would like to quote a few words about this. 100 years back, 200 years back, our scientists have found many inventions, maybe a telephone, maybe an aeroplane. Because of lack of the protection of property right, they lost. Now, Wright brothers are using this property right. This is one of the fate of India. As we all know, you have elaborated patent rights, designs, trademarks, copyrights, GI tag, etc. As far as the GI tag, I want to quote one example. Recently, in our district, there is one taluka called as Indi Taluka. Indi Taluka is famous for growing lemon. It has got a GI tag recently.
Wow.
Indi Taluka, it comes under Vijayapur district. Recently, it has got a GI tag. A famous quality lemon grown in this area. Both the Indi Taluka and the Sindhiki Taluka covered this crop. Sir, you have told about the tangible and intangible properties. This intellectual property right is an intangible property because it can be seen, it cannot be seen, it cannot be touched, it is invisible. So it comes out of inventions, it comes out of knowledge, it comes out of skills. It is very important to protect such a this intellectual property if it is not properly protected. We have covered various aspects, as I told, designs, patents, copyrights, trademarks, etc. This copyright is a exclusive right of ours. If it is registered, no one can be used. It means that registration is very, very important. Otherwise, it can be used by others. So registration is very important, and patent right has a 20 years life. Apart from patent rights, you have clearly explained about designs, about copyright. As we, the teachers, must and should know about the copyright, because we write books, we write many research articles. The protection of our writing is very important. So this work, etc., all these to be protected today. And you have clearly distinguished between the owner and the author of copyright. Who is the owner and who is the author of copyright? The owner can protect the copyright, as you told well. So you have elaborated all these things very nicely in a simple manner. Even the students of graduation level can easily understand. So on behalf of our chairman, on behalf of our faculty members, organizing committee, and delegates, special thanks to you, sir, because you have accepted our invitation and spare your valuable time with us. Nearly 2 hours time already. 1 hour 55 minutes have gone. So you have spent your valuable time with us and shared experience and knowledge with us. By this, we all are enriched about this copyright, patents, etc. And it is very, I feel it is very, very useful to all of us. Once again, thanks you. So thanks to all. Thank you, sir.
Thank you, sir. Thank you so much for giving us the opportunity. Actually, we are blessed to have that opportunity to spread the awareness among the students and the faculties. And I have been to Bijapur twice and to many colleges actually. And it
Yes,
was
sir. Last
very,
year you came, sir.
yes,
Last year, one session, offline session, sir, that on research methodology you
yes,
explained.
yes,
Yes, sir.
And
So eagerly we are waiting, sir, from you here.
sure,
So
many times we are permitted, we will do it, ma'am, not a problem.
yes, sure,
And
sir.
it was indeed a great,
Thank you, sir.
experience. In Bijapur, in all the colleges,
Yes.
I had a nice experience. It was actually good. Thank you. Thank you.
Thank you, sir.
Sure.
Now it's a time to thank all dignitaries and participants who are actively participated in the session. Hence, I request Ms. N.R. Chowkimat to propose vote of thanks. Over to Chowkimat. Honorable dignitary.
Hello? No sound, ma'am.
Honorable dignitaries, distinguished guests, respected principal sir, and dear participants. On behalf of Sri Kaskateshwara College of Arts, Commerce and Science, and the entire fraternity of the institution and organizing committee, it's my privilege to propose the vote of thanks to resource person, Mr. Abhishek Singh, Assistant Controller of Patents and Designs, National Intellectual Property Awareness Mission, NIPAM, Patent Office, New Delhi, who spared the time for his busy schedule to grace this webinar with his great, extremely relevant information on fundamental of intellectual property and rights. I would further extend a hearty thanks to Chief Patron of today's event, Sri V.C. Hiremat, Chairman, V.V. Sangha and SK College of Arts, Commerce and Science, Talikoti. I take this opportunity to specially express my deep regards and gratitude to Sri R.V. Jalwadi, Principal, SK College of Arts, Commerce and Science, Talikoti, always encouraging us and providing opportunities to organize such events. I would specially thanks and appreciation to all the participants who chose to live with us and attended the webinar with a great enthusiasm and made it successful event. My sincere gratitude also goes to the organizing committee, Mr. K.B. Desai, HOD of Geology, and the convener, Mr. S.S. Mane, HOD of Chemistry,
and co-conveners, Physics Department, and IQAC Coordinator, Dr. A.S. Alalmat, HOD of English, for taking this topic that really matters. And special thanks to Girija Nimbar ma'am, Department of PG Studies in Physics, KCP Science College, Vijaypur, who helped a lot to make this event happen. Last but not the least, I'm thankful to Mr. I.V. Rudgi and G.B. Kulkarni for all the technical support and all the coordinators and the teaching staff and non-teaching staff for helping us. Once again, thank you all, and great day ahead.
Thank you, ma'am. Once again, I thank you all for your cooperation and making a grand success of this event. We share feedback form in Telegram group. Kindly fill and submit it so that you will get an e-certificate. Thank you one and all.